Hello friends, Namaskar. I am Anil Kumar Srivastava. I shall today discuss remaining articles of the Directive Principal State Policy. I have yesterday discussed some important articles of Directive Principles. As I have already told you that there is a difference between the fundamental right and Directive Principal State Policy. But this is the difference is only to the extent that a person cannot go for redressal of their grievances under Directive Principal State Policy. But as far as the government is concerned, it is the fundamental in making the policies for the government. So for the public. So while the government, or as far as the government is concerned, it is a fundamental when the certain policy is being made for the people, the principles enshrined in part 4th of the Constitution must be followed. And suppose they does not follow it, what will happen? Suppose a government is not making any policy for the recruitment of public services, what will happen? The government will go after the 5 years to the polls and the public will vote against it. And suppose a government is not making a policy for the welfare of the workers, then what will happen? Workers will not vote in their favor and the government will go out. And some other examples can also be given. If the persons below poverty line are not being cared of, what will happen? They will not give vote to the government and government will go out. So these policies are fundamental as far as the government is concerned. But as far as the court is concerned, they cannot go to the court for the redressal. But as far as the two chapters are concerned, these both chapters are in a way both are supplementary and complementary to each other. Now the section 46. Section 46 talks about educational and economic interest of the weaker section of the people. And these weaker section of the people generally they belong to the SC and ST because they were far away from the development for the last 1000 years or 2000 years. So they have been given the security by the government. They should be given security by the government for their education and for their economic development. And some other class is also traced as for the example EWS, and it is equal to that SC and ST. So then that clause will also be covered under the under the Article 46. And if we go to the Article 47, there are 4 things here: the standard of living, the public health, intoxicating drugs and ban of these, and nutrition. So here we also talk about the nutritional factor, because if they do not get suppose for example the child does not get proper nutrition, and suppose the pregnant women does not get proper nutrition, and how can we improve their health? And if their health is weak, then they cannot serve the nation and their output will be very less. So the public health is very important factor, and nutrition is very important factor. Living standard is very important factor. So these things must be done, and it is for these factors, say for the Article 46 and 47, the government has made many laws. For example, the NFSA has been made, National Food Security Act, and both these articles are concerned SC, ST and BPL category, and all those are given the free food under NFSA, National Food Security Act. So this is the duty of the government, and the government is doing for that. Nearly 80 crore people are getting free ration from the PDS. So it is the application of these articles 46 and 47, the mandate of the 46, 47. And if we are giving midday meal to the children, it is also covered under 36, 37. The government is doing for the same. Government is mandated for doing so. And for the pregnant women, they are giving, Anganwadi department is doing for the pregnant women and for the Anganwadi 0 to 6. And as I have already discussed you, the 0 to 6 years of children are to be cared by the government under Article 45 of the Indian Constitution, Directive Principles. So here we see that all the policies are made in order to implement the Directive Principles. The Directive Principles are since fundamental, and fundamental because if they do not do, if the government does not do, the government is not caring the interest of their people, and the government has no right to live in office, and so that when the time will come, the people or public will throw them out. And next section, Article 49. Article 49 talks about the breeds, about the scientific development of the animal husbandry, and this animal husbandry is very important because and under this article the cows cannot be slaughtered. So there is a bounden duty of the state government that every government should follow, that our cows should not be slaughtered, our other animals should not be slaughtered. So and government also think to make its breeds better, there should be a cross breed, etc., so that their species can be made better. So the government is in this article mandated to take care of the animals and other category of these animals. And under 42nd Amendment Act, Section 48A have also been included. In 48A, it has been prescribed that wildlife must be taken care of and the forest must be taken care of. And in Goda Burman case, the government has given that all kind of plantation should be counted in the forest. In Forest Act 1927 and in Forest Act 1980, the definition of the forest has been made, and it is the duty of the government to make the more and more forests should be there. In Goda Burman case, the government has said that the court has said that the government should count the plantation on the public and private land also as a forest, and the forest should also be secured. But a new act has now been passed, and under which the government has made some kind of exemptions for the LOC and LAC, and it also said that the area which is not written as registered as a forest under 1927 Forest Act or 1980 Forest Act will not now be counted as forest. So these exemptions have been given under the new rules, new act which has been now passed. And if we come to the Article 50, that is related with the separation of If we come to the Article 49, Article 49 talks about the Archaeological Act 1951. The places which are important for us as a cultural importance, for example, Konark, Surya Mandir and Khajuraho and Elephanta caves and other things, Sarnath. These are the important monuments of the cultural importance. For example, Taj Mahal, and there are many such things which are categorized as the national monument. They should be served and they must not be disfigured and they must not be destroyed. It is the government duty of the government to save these things. An Archaeological Survey of India is responsible for saving these things. So, because these are the cultural importance, and culture is very much important for us because we live in the culture and we don't forget our culture. It is provided in our fundamental duties. You can see that our culture should be saved at all cost, our forest should be saved at all cost, and there should be dignity for the integrity of the India. These things have also been tabled or classified as fundamental duties. And if we talk about the Article 50, this talks about the separation of power between the executive and the judiciary, and this is based on the principle that no person can be a judge in his own case. Suppose executive does some kind of order, and if judiciary belongs to that, then what will happen? The same person will be deciding his own case. Thus, the person who is from the executive is also holding the post of judiciary, then he cannot give a fair judgment because he is the same person, and it is because of making the judiciary and executive totally different. And for this, Article 121 has been included in the Constitution, which says that there shall be no discussion on the behavior, on the conduct of the court cases in the legislature, in Lok Sabha or Rajya Sabha. It is because to avoid these things. And similarly, Section 122 has also been added, and which says there shall be no discussion as far as the irregularity of proceeding is concerned in the four walls of the Lok Sabha or Raj Sabha or Vidhan Sabha. So court cannot take about these irregularities or the things which are being done within the four walls of the legislature. It is because we have made executive and judiciary totally different, and because the judiciary is not separate from the executive, then there can be no justice for the people. And Article 51 says about that the government should always make respect and foster respect for the international law, and should also make law for the implementation of international agreements, and the international peace and security should also be preserved, and all kind of disputes must be solved through arbitration. There should be no violation of these international law. For example, India is a member of the United Nations, and so India cannot disobey the United Nations Charter, and India has also signed the Vienna Convention Treaty, and we cannot, as a government, can disobey, can contravene the provisions of the Vienna Convention. For example, India has signed the Treaty of Moon, and moon settlers. So here we have not ratified the treaty, but we have signed it. Every government and every state has got a different way of ratification. So we have signed, so it has become bound. We will be bound only after the ratification. So there are many international agreements to solve the problems relating to the disputes of international kind, of international border. We should also always resort to the peaceful means, and we should also always respect for the international law. So these are the principles which I have already I have told you, and this is the duty of the government to follow these laws. So we come to the end of today's discussion on DPSP, and I shall tomorrow tell about the Article 44 and Article 45, and thereafter I shall deal with the court cases regarding DPSP. So that's all for today. Thank you.